Manhattan Property Division lawyer dividing property in a Manhattan divorce can shape your financial future for years to come. New York does not automatically split assets equally between spouses. Instead, courts use equitable distribution, which means marital property is divided based on what a judge considers fair. That process usually begins by identifying all assets and debts connected to the marriage. The court then classifies each item as marital property or separate property before assigning value. Marital property generally includes assets and debts acquired during the marriage, regardless of whose name is on the title. That can include co-op apartments, condominiums, investment properties, bank accounts, brokerage accounts, retirement contributions, businesses, vehicles, furniture, and even certain bonuses or deferred compensation. Separate property usually includes assets owned before marriage, inheritances, gifts from third parties, personal injury settlement proceeds, and property protected by a valid marital agreement. A major issue in many cases is commingling, which can happen when separate property is mixed with marital assets. When that happens, the spouse claiming the asset is separate may need clear and convincing evidence to prove its origin. A Manhattan lawyer can help identify, classify, and protect assets before avoidable mistakes affect the outcome. Courts in New York also look at many statutory factors when deciding what is fair. Those factors include the income and property of each spouse at the time of marriage and divorce, the length of the marriage, and the age and health of both spouses. A judge may also consider the need of a custodial parent to remain in the marital home for the stability of children. Other factors include the loss of inheritance and pension rights, the loss of health insurance benefits, and whether spousal maintenance has been awarded. The court can weigh homemaking, child rearing, and career support as meaningful contributions by a non-titled spouse. It may also examine whether assets are liquid or hard to convert to cash, along with each spouse's future financial circumstances. Tax consequences matter as well, especially when real estate or retirement accounts are involved. If one spouse wasted, hid, or transferred assets in contemplation of divorce, the court may factor that into the division. In Manhattan divorces, high-value assets often require especially careful analysis. Real estate, business interests, professional practices, and retirement accounts may need appraisals, forensic accountants, or legal tools such as a qualified domestic relations order. New York law also distinguishes between enterprise goodwill, which may be divisible, and personal goodwill, which generally is not. Complete financial disclosure is essential because both spouses are required to provide a full accounting of assets, income, and debts. A property division attorney can also review whether a prenuptial or postnuptial agreement changes the usual equitable distribution rules. Some disputes can be resolved through mediation, collaborative law, or negotiation between attorneys instead of trial. Still, when a spouse refuses to cooperate or hides assets, litigation may be necessary in the New York County Supreme Court. If you are feeling overwhelmed by questions about your home, retirement savings, business interests, or debts, a trusted law firm can help you understand your options and protect your financial interests. If you need compassionate guidance, the law office of Richard Roman Shum, Esq., is here to help at 646-259-3416, and if you are ready to speak with an attorney in person, the office is located at 20 Clinton Street, FRNT 5D, New York, New York, 10002, United States.